Hey everyone, just wanted to send you guys a message today to talk a little bit about the NAR lawsuit that's been going on for the last year or so, and some updates on it. Just want to share with you guys. Hang on, let me get this going. Okay, so we're going to talk about this NAR lawsuit, what's happening with it. Some of you may have already heard about it and what's happening. It's been kind of in the news for the last couple of years, and but there have been some recent developments on it, and wanted to kind of share with you guys. I had some questions about it from several people. I thought it might be good to let's go ahead and send out a little bit of recap on it. So let's talk about it a little bit. First off, what is it? What is the lawsuit about? We'll talk about who's involved in it, what the claims are against NAR and some of the other companies, and then we'll talk about what are some of the proposed settlements and what it means to us as agents and how it's going to affect us. So who is involved? Basically, it's NAR. It was two different lawsuits that were brought by class action lawsuits. Department of Justice got involved, but basically it involves the National Association of Realtors, company called Anywhere, which used to be called Realty, and they basically own all the companies there: Coldwell Banker, ERA, Century 21, Sotheby's, and Cochrane. Home Service of America, which is Berkshire, Keller Williams, and Remax. These are all the companies named in the lawsuit. So what basically the claim is that these companies supposedly, according to the claim, have forced home sellers into an unfair system that requires them to pay a commission that is split by the buyer and the seller by the following ways. Number one, prohibiting multiple listing services from disclosing to prospective buyers the amount of commission that the broker will earn if the buyer purchases a home listed on the MLS. This is basically, where we log into our MLS system and we see the co-op commission, but that co-op commission is not shown on public websites. So, and this is something we've already seen starting to change. We're starting to see the MLSs start to put the co-op commission that's being offered in the public side, and that's to disclose to buyers, what the commission that their buyer's agent is going to receive. The second one is allowing buyer brokers to mislead buyers into thinking that broker services are free. And even though not everyone does this, this is something that unfortunately does happen, where agents will inadvertently say to a buyer, well, I work for free, or, you don't have to pay me, which is technically not true. Because even though the buyer's not having to write a check for it, the commission is being paid out of the commission and out of the house sales price. So this is one of the other issues. Number three, enabling buyer brokers to filter MLS listings based on the level of buyer brokerage commissions offered, and to exclude homes with lower commissions from consideration by potential home buyers. So obviously, none of us do this, but there are agents in the industry that will do searches based on co-op offered, and I've heard of agents that have said they wouldn't show a property if the compensation is not a certain level. That's obviously not a good thing. And number four, limiting access to lock boxes that provide licensed brokers physical access to a home that is for sale to only those real estate brokers who are members of a NAR affiliated MLS. Whereas in our area, we don't think of it that way, because we have Georgia MLS and we have FMLS and different MLSs that we access. And they're not required to be members of boards. Members of the National Association of Realtors to join. But there are some exclusivity issues when it comes to the MLS systems. So in this lawsuit, we're not going to get into the details of what was said or what the comments were, but basically just recently, Anywhere revealed they're actually proposing an $83.5 million settlement in the lawsuit, and Remax has proposed a $55 million settlement. Both companies have said that they're not admitting any fault here. They're just trying to keep from having this lawsuit continue to cost money for them and any of their members and things like that. So that's that. And this proposal will go before the court in January, and they'll most likely will go through. But And this is a comment from NAR. NAR vowed not to settle and said the proposed settlement does not change how the case will be presented in court. And the quote is, based on their latest filing, it appears that they are agreeing to do things already required by our code of ethics and our or MLS rules. So just like the setting of the commission, we all know and understand and repeat to people that commissions can't be set. Two brokers can't conspire about a commission. It is a negotiable item. And as you already have seen, there are different amounts of commission being offered in the MLS under the co-op section. So we're not seeing a set rate, even though sometimes it may feel that there's an average, but you do see variables on the co-op commissions. So what are the terms of the settlement that RE/MAX and Anywhere have come to? These are the terms. Number one, NAR membership is not required. That's one. We're going to unpack these three settlement terms in a minute. The second one is agents must disclose that commissions are negotiable. That's the second one. And the third one is no minimum commission requirements. Okay, those are the three terms of the settlement, along with, of course, the money. The takeaways that I wanted to kind of go over with everyone. So let's talk about what does this mean, this franchise, this broker membership, NAR membership not required. This is not an agent issue. I understand what this means is a franchise like RE/MAX, like Anywhere, any of their franchises, in their broker agreement with their franchisee, the person who purchases the franchise, each office independently owned, they had a requirement that they had to join the National Association of Realtors. So that meant that every agent in their company had to join as well. So what they're saying here is that they are no longer going to require the brokers of each office to be a member of the board, but the brokers of the board will have a choice. And if they choose to join or stay a member, then all of the agents in the company will have to be a member. So it's not an individual basis. It's not saying that the individual agents can choose whether they join or not. It's really up to the broker. And my guess is, most all of the brokers will remain members of the National Association of Realtors. So you're not going to see a lot of agents leaving the board of Realtors, in my opinion. The second one is do not assume MLS compensation. You can't just assume, and you shouldn't be even now, even a few years ago before this lawsuit, we've seen commission amounts be all over the place on the co-op commission. I've even seen zero a couple times. This has been several years ago. It was actually an auction company, and they were offering 0% co-op. And that's you need to be aware of what you're showing before you go out to show the properties. Commissions are negotiable. You need to verify your co-op commission compensation. That's number one. Number two, do not tell your buyer that your service is free. And you shouldn't be doing that already, but just be aware that is that is the reason, one of the reasons that they had the lawsuit in the first place, is because buyers were being led to believe there was no cost at all for the buyer, for their service, but for the buyer's agent service, but that's not the case. Do not tell a seller, if you don't pay at least X commission, agents won't show your house. We know better than that too. You can, in my opinion, you can explain it to a seller and say, this is, the co-op commission is how we incentivize other agents to show your property, and I recommend this or that. But you can't say, well, if you don't pay this commission, this amount of commission, then no one's going to show your house. That's something you do not want to be saying. And the last one is obviously don't refuse to show a property based on co-op commission. So we've seen a lot of variables in MLSs that we are members of. We've seen, of course, you guys have seen comments in the private remarks, if buyer's agent must be present at initial showing, or the co-op commission will be whatever, 1% or something like that. And understand that is legal, but also understand that that's only legal if that breakdown of commission is in the listing agreement. So most likely the agents who are putting that comment in their listings are not putting that criteria or that stipulation in their listing agreement, because they really don't want the seller to know that they're being a little bit greedy. So if that's something that you choose to do, which is perfectly fine, you need to make sure you're putting it in your listing agreement as well as on the MLS, because that's the only way it's truly legal. And if someone asks you to see a copy of your listing agreement, and you, because of that stipulation in the MLS, you would need to provide that. So these are all just things that we should be doing already, but just takeaways for sure. Another thing, this is something that the conversation has been a good bit lately, has been the concern about what's going to happen. Now that the commission is not going to have to be a certain amount, you might see some ones and zeros and all kinds of things. Argument about, well, maybe you have to show $1 or whatever it is. But what it comes down to is, it's going to be very important that we start treating buyers the same way we do sellers. And that's and what I mean by that is, of course, no one would think it was reasonable if a seller called them and said, "Hey, I want to list my house, and if you'll go ahead and put it in the MLS system, I'll sign the listing agreement next week, or I'll sign it, when you bring me a buyer." You would think that was crazy. You wouldn't think, well, you would say, well, that's not how this works. I can't do that. And but we don't think twice about working with the buyer and working with showing them properties, and we just think, oh well, they're going to use me. I know them, or this is a friend or relative, or this is whatever the issue is. But we have no problem working with the hope that we will have an agreement or get compensated with buyers, and that's just not something that we're not going to be able to do that going forward. We're going to have to make sure that we're protected. So the buyer consultation is going to be very important going forward. You're going to have to be able to be knowledgeable. You're going to have to explain agency and compensation, and that's something that a lot of people don't feel comfortable having that conversation. And it's a matter of knowledge, but it's also a matter of repetition. Once you start having that multiple times, you'll feel more comfortable with it. But you're going to have to be more versed in agency, explaining what that means, explaining what you can and can't do for someone if they're a customer versus a client. These are things that are going to have to be part of your toolkit. In establishing your value, why would someone want to hire you, et cetera. And then asking for the commitment. You're going to have to start asking for the buyer commitment, just like you will a seller. And I've been saying this for years, probably 6-7 years as I've been teaching ABR. It's very important that you get a buyer brokerage agreement signed, and that you put in the buyer brokerage agreement the compensation that you are expecting to receive, and that you make the buyer brokerage agreement, you make it require the buyer to be responsible to pay you in the event that you're not paid by the co-op agent or the seller. In the event of let's say a for sale by owner or co-op commission is lower than what your expectations are. You're going to have to start doing that. And there's reasons why you need to do that are beyond just, you trying to secure your compensation. There are tools that you can use in your arsenal that will make sure that buyer is never going to be in a position where they are forced to pay that commission. And that's something that we talk about in the ABR class that I think everyone needs to have to take that course. Here's an example what I'm talking about. So let's say you have a buyer and you have a counseling session with them, and you explain to them, that what agency means, and that, well, if I'm representing you as a customer, I'm only allowed to answer questions and fill in blanks. I can't give you advice. I can't give you negotiating strategies. I can't even pull a CMA for you if you're a customer. That's the truth. That's what the license law says. If you're a client, then I can act on your behalf. I can give you information. I can give you advice. I can give you comparables, and I can truly represent your interests. And so let's say you had that conversation, you expressed your value, you got the commitment, and you explain to them, this is what the buyer brokerage agreement is. This is what the compensation is. Understand that that in the event that I'm paid through the MLS system, then this will take care of that. If not, there are strategies that we can use to put into our contract so that you're not in a situation where you're forced to pay this commission. And what I mean by that is, everyone knows or should know that it is a license violation and an ethics violation for you to negotiate your commission in a contract. And what I mean is, you can't say in a contract, for example, let's say the co-op commission is lower than what your expectations are. You can't go in with your buyer and make an offer on the property and say in the special stipulations, you can't say buyer brokerage commission to be X, or, listing broker shall pay X, Y, Z to the buyer broker. That's a license violation. It's an ethics violation. The reason why it is because it's simply, you can't negotiate one party's compensation on another party's contract. That's the bottom line. So what happened is the contract is actually a contract between the buyer and the seller, not between the brokers. Okay, the brokers have a different agreement. They have the listing agreement, they have the buyer brokerage agreement, but that's the reason why you can't negotiate, because you are going on to someone else's contract. As a matter of fact, the listing and the selling broker's signatures don't even have to be on the contract for it to be legal. Only the buyer and seller's signatures are required. Everything else is just there for information. So, but however, the buyer can negotiate with the seller. Okay, so what that means is, the buyer is in the ABR class. I've actually pulled a stipulation out of the class that the NAR has given us. This is a stipulation that they give about how the buyer can negotiate the compensation to their buyer broker. So here's the stipulation. It says, seller and or any third party to the settlement and transfer of this property agrees to pay buyer X% of the sale price to settle their contractual agreement with their buyer brokerage at closing. So notice it says seller agrees to pay buyer X. Okay, so that is what's happening in this contract, is that the buyer and the seller are negotiating. It's no different than closing costs. So if, let's say, the buyer says to you, "Oh, I don't have enough money for my closing costs." Well, what do? You go into the contract and you negotiate the buyer is asking the seller to pay their closing costs. Same exact thing in this situation. If they don't have the money to pay the buyer brokerage commission, then you use this stipulation in the contract to say the seller agrees to pay the buyer X% of the sales price, or the difference. You could say the difference in the buyer brokerage commission, the difference in what's being offered in the MLS as a co-op commission, and X. So it could be that you're just saying the difference. So this is one example of how you can battle that issue with your buyer brokerage agreement. Understand too, another thing I want to point out, because it states here, pay buyer X% of the sales price to settle their contractual agreement with this buyer broker. What that means is, if you don't have the commission that you're expecting to receive in your buyer brokerage agreement, and you also have to have that the buyer is responsible to pay you if you're not compensated. You can't say the buyer's not responsible, because if you say they're not responsible, then of course they don't have a contractual agreement. They don't have an obligation. So you have to have the commission in your buyer brokerage agreement, and you have to have that the buyer is responsible. That's the only way the stipulation is enforceable. So just keep that in mind. And again, most of the things that we're talking about in this lawsuit and the things you will cover in detail and get the information and tools that you need to be successful from there in the ABR course. And by the way, if you've already taken the course, then you can sit in on another one to review it again. And we don't charge for that. So make sure, whether you take it from us or online or whatever, but some of those stipulations and things are very important. So I recommend everyone to get the ABR designation, take that course. That's all I have for today for the news about the lawsuit. There'll be more information coming out, and we're going to continue to follow the lawsuit from NAR perspective to see how it all comes out. And hopefully you guys learned a little bit today and got some tools. So if anybody has any questions about anything we talked about here, or want to just discuss it a little further, don't hesitate to reach out to me, and we'll talk more about it. All right, guys, have a great week, and